South Carolina Gun Laws 2025. You might think it's open season until you walk into the wrong building. Welcome to South Carolina, home of barbecue, beaches, and now permitless carry. Since 2024, if you're 18 or older and not prohibited, you can carry open or concealed without training, without a permit, and without telling an officer you've got it. Sounds awesome, but here's the kicker. Mess up the details, and you'll find out how fast that freedom gets expensive. Chapter 1. Buying a gun in South Carolina. Buying is easy. No state permit, no waiting period, no registration. Dealer sales still run through the federal background check, NICS. If NICS can't immediately approve or deny, the dealer can legally transfer the firearm after 3 business days. This is the federal default proceed rule, sometimes called the Charleston loophole because of the 2015 church shooting. Now, private sales, no state requirement for a check. Now, after making so many videos on states that trample on gun rights, it's nice to come across this. Good going, South Carolina. Chapter 2. Constitutional carry in South Carolina. Carry open or concealed at 18. No duty to inform law enforcement that you're armed. Now inside your vehicle, anywhere you want. Glove box, console, even on your lap. I mean, I wouldn't recommend it on your lap when a police officer shows up, but yeah. So why keep a concealed weapons permit, CWP? Well, it works across state lines, also known as reciprocity, and a valid South Carolina CWP lets dealers skip the NICS call in many cases, making purchases faster, and it protects you from the 1,000-foot federal school zone trap. Chapter 3. Where you can't carry in South Carolina. The list is long, but here's the short version. Courts, law enforcement and correctional facilities, schools, churches without permission, hospitals, government meetings, and private homes without consent. Oh, federal buildings too, obviously. Now, about those quote-unquote no-gun signs, let's clear the air on this. If the sign is posted the way South Carolina law requires, right size, wording, placement, etc., it has legal force. If it's not compliant, then it's just wallpaper. Now, I'm not going to go over all the specifications. There's a few. The exact specs are spelled out on South Carolina Code Section 23-31-235. So here's the deal. Ignoring a proper sign isn't a gun crime, but it is trespass. And if the manager asks you to leave and you don't, that's trespass too. Now you combine that with a compliant sign, and now it's trespass with a weapon. Now that's the kind of case prosecutors love to make an example out of. Moral of the story is, respect property rights, but you should probably check out our concealed carry apparel. Chapter 4. Penalties and prohibited persons. People were so happy when constitutional carry passed, as they should have, but it came with a catch. South Carolina actually went harsher when they passed constitutional carry. So felons in possession, and that felony could be anything. First offense is up to 5 years, second offense is 5 to 20 years, mandatory 5, and third offense is 10 to 30 years, mandatory 10. And the other one is commit any crime in possession of a gun. And I mean, you don't even have to show it. You get an extra 3 years on whatever crimes you've committed. Only CWP holders are exempt from the 3-year penalty when committing a crime with a gun. See, it's more than just to get on a list. Oh, and you now have 10 days to report a lost or stolen firearm. Good luck. Chapter 5. Stand your ground in South Carolina. This is a castle doctrine, stand your ground state. No duty to retreat if you're in your home, car, or anywhere you legally belong. Deadly force is justified to prevent death, serious harm, or a violent felony. But the key word here is reasonable. You can't start the fight and then claim self-defense. Some folks think stand your ground means shoot first, ask questions later. That's Hollywood. In real life, juries look at the details. If your story doesn't hold up as reasonable, you're in the hot seat. And if you're the initial aggressor, or you're committing a crime, stand your ground protections can evaporate. Now, if you're found justified under stand your ground, South Carolina law gives you immunity from civil lawsuits, which is amazing. That means the bad guy's family can't turn around and bankrupt you with wrongful death claims if the court says you acted lawfully. Chapter 6. Federal landmines. Now, South Carolina may have gone permitless, but federal law still calls the shots. And these traps catch people all the time. Under the Gun-Free School Zones Act, you can't carry within 1,000 feet through a K-12 grade school unless you've got a valid South Carolina CWP. Constitutional carry doesn't count. Then, federal law bars felons, domestic abusers, fugitives, unlawful drug users, and the mentally adjudicated from possessing guns. And my least favorite federal landmine, Suppressors, SBRs, machine guns, those still need federal tax stamps, no exceptions. Ugh. You know, South Carolina gave its citizens constitutional carry, but also built in some heavy penalties. Look, if you found this breakdown helpful, drop your state in the comments. We'll cover it next. And if you want to carry in comfort without printing, check out Relax Fit Tactical. Our CCW joggers, shorts, and tees are built for the real world, not just the range. Stay safe, don't be lame, subscribe.